is represented online. Donor Aviation, can you hear us?
Yes.
Your name, ma?
Yes. We're online.
What's your name, ma? Donor Aviation.
No, this is AG Hamza E Esquire, lawyer representing Donor Aviation.
Not the lawyer, sir. The representative for Donor Aviation.
She is also online.
What's her name, sir?
Ngozi Ike.
Ngozi Ike. What's her position, sir?
She is the legal officer.
Legal officer, my lord.
Okay.
My lord.
Okay. Appearances. Yes. Adeleke. Adebot. Esquire.
Sure.
Okay. Yes. Okay. Esowe with you is who, please? Mr. Adepoju. Okay. Ugochi. Okay. All right. Yes. Miss,
With the greatest respect and humility to Muhammad Hamza AG,
okay. Yes.
I humbly announce a clearance for the second defendant.
Very well. What is the business of the court today? Process of the DW2. Okay. Who testified as DW2 on the last occasion? Okay. Ngozi. Ngozi K. Ngozi K, can you hear me?
Ngozi, unmute your mic.
Okay, I can hear you now, my lord. Yes, my lord.
Yes. So the business of the court today is for somebody to cross-examine you. I hope you're ready.
Yes, I'm ready, my lord.
Very well. Please remember that you're still bound by the oath you took on the last adjourned date.
Yes, my lord.
All right.
Given the alignment of interest of the first and second defendants,
yes,
may we, or we're applying that perhaps the second defendant should cross-examine because if
No.
Okay.
No.
And the reason is simple. That has played out in the other system. They have a way of trying to do whatever it's we have done with Ngozi.
No.
If my lord is not minded to make that order, I want to just put it on record that.
No, say it again. I want to.
The application I'm making is that given the alignment of interest,
yes,
the case of the defendants,
yes,
we will be applying to that the second defendant,
yes,
no, the first defendant rather, cross-examine Ngozi for the case first.
Okay.
Okay.
Yes. So, counsel, you heard him.
My lord, we strongly object to that line of proceeding.
all my witness, everybody so there's no reason why you are unless you say it's not going to talk. Whether this similar, whether it's not the same, it should be for him to address what I meant. By this point, he's no for example. For it to be said as programming that's ability by people.
Counsel, are you ready to cross-examine?
I'm ready.
Very well.
Ready. And we'll go ahead. And I'm happy that this is already on record. Again, like I said the other time, these are already played out. In fact, that's why we brought the motion in the other suit. When what they will be doing in cross-examination is to keep repeating the same questions we have asked Ngozi, for which we have elicited answers. But my Lord, I'm happy to go on.
Okay.
We know how to do all these issues. I'm most grateful.
Yes.
So the witness that we brought. And we need to and decide to present the case on any so to be facing the question that something, since you know that since you got us before, let us do our case in great whether we allow you to accept, whether we challenge that. That's not your business.
Very well.
Let us do that. It's now I mean, it's your way.
Anyhow, he said he's ready to. Yes.
Ngozi.
Yes.
Yes.
In paragraph
Yes, my
7
lord.
of your statement on oath,
He's asking you a question. Yes.
you mentioned that the first defendant was sent to the second defendant on secondment. Do you confirm that statement? Ngozi, can you hear me?
I didn't hear what you said.
Okay, I'm repeating it again. In paragraph
Okay.
7, you mentioned that the first defendant was sent to the second defendant for secondment. I'm asking you whether you confirm that statement.
Yes.
Why don't you say yes?
Yes.
So, by secondment, you confirm that the first defendant worked with the second defendant. Did you confirm that the first defendant worked with the second defendant, even though it is on secondment, or he was on secondment?
Yes, he was sent to the second defendant to work with them on secondment.
Thank you, Ngozi.
Yes.
So working with the second defendant included flying the second defendant's aircraft. Yes or no? Did that include flying the second defendant's aircraft?
Yeah, flying was the main thing actually for the first defendant.
I didn't hear that.
He said actually the main thing he was doing was to fly.
Thank you, Ngozi.
Yes.
Now, Ngozi, the first defendant was the first defendant, the first employee to leave the claimant and work with the second defendant. Do you know whether the first defendant in this case was the first employee to ever leave the employment of the first of the claimant to work with the second defendant? Do you know?
Please come again. What?
So I'm asking you whether you know whether the first defendant in this case was the first ever employee who left the employment of the claimant to work with your second defendant. I'm asking you whether you know. If you don't know, tell my lord.
I wouldn't know if it's the first. It's a company. How will I know if that is the first defendant? I don't know.
Thank you.
Yes.
Now, you co-authored the letter dated 9th October 2014. Registrar, please, I need the exhibit. I need to know what exhibit that is. There's a letter on record that is dated the 9th of October 2014, which you co-authored.
A letter what?
Hold on, because it's dated 9th October 2014. It's part of the evidence before the court. I want to confirm what exhibit that is.
Allahu Akbar, Allahu Akbar. Allahu Akbar, Allahu Akbar.
Come and bring it to me. Let me mute it. I will mute Mr. Hamza.
My lord.
Mr. Yes, I'm afraid I'll mute you for a minute or so.
But I can hear all
Because-
that is transpiring.
Okay. We are also hearing the call for the faithfuls to pray.
Yes.
And
I
it's
was using my mobile phone.
okay.
My lord, it was a mobile
Okay.
alert.
Okay.
Yes.
Will it come back anytime soon?
I'm not going for prayers.
Okay. But they will still
not
call
going
you
for
for
prayers.
prayers. Okay.
No.
How about the what do they call it when they sing that? Eh? Okay. All right. That's all right.
Yes. Thank you, my lord.
Yes. Counsel, you say a letter dated when? What year? 2014.
It's exhibit C22 now.
Okay, then 9, 10 of which year? 2014. What year?
2014.
14. Okay. Which is exhibit what?
Exhibit C22 now.
Okay.
Because you co-authored that letter. Is that correct?
I don't understand.
Because he's saying that there's a letter dated
Okay.
9th of October 2014. That is exhibit C22. He's asking you whether you co-authored that letter.
I wouldn't know the letter now. I have to see it to know.
My lord, may she be sorry, my lord, may she be shown the letter to refresh her
We
memory.
will show you the letter now.
Your signature is there. You are one of the people who signed that letter. Exhibit C22.
Ngozi, can you see this? Look at your screen. Look at your screen. Ngozi, are you looking at the screen?
My lord, I can also not see clearly who signed.
You say your signature
Let
is
us see the signature.
Let me.
Caption of the letter.
The caption is re-solicitation of Overland Airways personnel and inducement of breach of contracts of employment.
Okay. Can I see who signed the letter, please?
Okay.
You signed the letter. You and a certain Mark Snozel. I'm asking you to confirm that that's your signature.
Can you see it?
Yes, my lord.
Okay.
Yeah.
So you
I authored it. Yeah.
I'm grateful, madam.
Yes.
Yes.
Because in that letter, you did not mention that PMAS is the employer of the first defendant. Did you mention in that letter that PMAS was the employer of the first defendant? So yes or no, did you mention or did you not? It's very simple. And if you don't remember, I can tell my lord that you don't remember.
So even
Did you
the
indicate that
is the employer, but the fact remains that they were employed by PMAS and sent to us.
My question to you, because is very simple. Answer my question before. I'm saying that in this letter, under reference, did you mention that PMAS was the employer? It's yes or no question, Ngozi.
I wouldn't know all that was mentioned in that letter right now, but I'm trying to tell you that the issue is that this letter came to us direct, and we had to respond to this letter according to what was written, what was sent to us.
Witness has answered.
So, what was the question again?
Witness has answered.
My question is,
my lord.
In that letter,
Yes.
she mentioned that PMAS was the employer of the first defendant. And she, as far as I'm concerned, she says she's not aware of everything that was said in the letter.
Yes.
But are you aware that the first defendant mentioned that he worked with the second defendant? Are you aware that he said that? If you are not aware, just say no. Are you aware that the first defendant said that? Yes, are you aware that he mentioned that he worked with the second defendant?
Even here we have mentioned it. They were seconded to the second defendant, so they will work with them.
Yes. Yes.
Yes, my lord. Now, in that letter dated 9th of October, you had mentioned that you were investigating and that you're going to remit sums to the claimant based on your findings in that letter. That's what you said in that letter. My question is, did you remit any sums to the claimant in respect of the first defendant?
Sorry? I didn't get you right now. Please.
So in Exhibit C22, you mentioned that you were investigating the employees who left the claimant to work for the second defendant. You said that, and that you mentioned that you're going to remit sums of money through the claimant. You said that in Exhibit C22. So I'm asking you whether you remitted any sums to the claimant in respect of the first defendant.
I remember saying I will remit sums to the first defendant, to the claimant. I can't remember saying that.
I'm satisfied.
Yes.
Because you confirmed to my lord that the first defendant was flying the second defendant's aircraft.
Yes. That's what he was seconded to come and do, yes.
So you do also confirm that the second defendant was signing the first defendant's pilot's logbook, which is of course incidental. If he was flying aircraft, then the second defendant would have been signing his logbook as is required under the flight regulations.
Because it's a requirement, it's NCA requirement that if you fly an aircraft at the time you are required to sign a logbook, that is part of the job. They will sign it.
Yeah. Yeah. Yes.
Hold on. Let's make sure that I've got this.
Okay. Okay. You're bearing in mind the 40 minutes.
I'll barely use 5 minutes.
Okay.
Now, Ngozi, did you request for a discharge letter from the first defendant, from the claim before he was allowed to work? Do you understand my question?
I didn't hear you at all.
Okay, I'll repeat myself. My question is that you, before allowing the first defendant to work in the second defendant's employment, did you request for a discharge letter from the claimant? Did you hear me, Ngozi?
No, it's echoing and is wobbling. I never got anything you said, but I was hearing sounds. I never heard it.
Okay, let me try again. So my question is, did you Mr. Hamza, I think you should mute your system. I think that's the reason for the echo. So my question, Ngozi, is, did you request for a discharge letter from the claimant before allowing the first defendant work for the second defendant? Did you request for a discharge letter? Yes or no? You did. Tell my lord if you did not.
No.
My lord, I'm satisfied.
Yes.
My lord, I'm done with it.
Very well.
Most necessary.
Okay. Very well. So, let's see.
Yes, witness, can you please confirm to this honorable court who your old employer is? Who is your old employer? Who are you working for? Which company do you work for? Can you confirm to this honorable court your employer, your own employer? Who is your employer? Which company do you work for at the moment?
Did you get that?
Can you confirm to this honorable court your own employer?
Okay. Okay.
Okay, let me refer you to your paragraph 1 of your written position. You said you are the legal advisor to the second defendant. Is that true?
Did you say that?
Hello?
That you are the legal advisor to the second defendant.
Yes. I'm just
Yes.
reading the position. Is
Say-
that true that you are the legal advisor to the second defendant, Junior Aviation Limited?
Okay. Yes.
Can you confirm the employer of the first defendant? Can you confirm to this report the employer of the first defendant?
The employer of the first defendant.
Yes, that's Captain Akintomiwa Ojo.
PMAS.
Can you please
Personnel
give this
Management
report
Aviation Services.
slowly, please?
Eh?
Say that slowly, the full meaning.
Personnel Management Aviation Services.
Yes.
Can you tell the audience cause the year and date of employment of the first defendant by PMAS?
I didn't hear you, please.
Can you confirm
Okay.
the date and year of employment of the first defendant, Captain Akintomiwa Ojo, by the said PMAS? Where was he employed by them?
I think 21st September 2016.
What year was? Can you confirm the year?
You said 20 what?
2016. That's the employment letter we have at the moment.
From your experience as a legal advisor, you request for discharge letter from a new employee in any organization. Do you request for a discharge letter when you are going to employ somebody into any company? Do you request for a discharge letter from such individual?
In this organization, we have not been doing that.
Thank you very much.
Yes.
I think that's all.
Very well. Thank you. Mr. Hamza. Okay, that's your witness. So, of discharge. Council, this is Mr. Hamza's. Mr. Hamza,
Witness, yes, my lord.
Yes, they've concluded.
Yes, my lord, she's my witness.
Yes, very well. Is there any re-examination?
Yes, my lord, I wish to, yes.
Okay.
I wish to clear a little ambiguity from the cross-examination of the first defendant witness.
Okay.
Yes. Madam Ngozi?
Yes.
The first defendant asked you a question regarding when was the first defendant employed, and your answer was what is it called? If what I record is what the court recorded as well, your answer was according to the employment letter you have left you. Is that what you said?
Yes, that's what I said now. Yes.
Okay. So are you now saying that the employment is in 2016 or before 2016?
Okay, what happens is...
No, the objection is sustained. Because she answered it very clearly. There was no ambiguity.
My lord,
Mr. Hamilton, yes.
Yes, my lord.
my lord, I withdraw the second question. Let her answer the first question.
The first question has been objected to, and the court sustained the objection because there was no ambiguity when she was asked that question. Mm.
All right,
My lord.
Yes.
Yes, my lord. This employment we have that Mr. Ojo was given, normally they are employed by PIMAS 2 years. They employ them 2 years.
Okay.
So this particular employment letter now is the one that was made available to us. That because they employed them, he has been employed before that time, but this particular employment letter is the one we have because the present one. Normally, when they renew after 2 years, they renew their employment, and after when they renew your employment, they give you a new employment letter. That's what I mean by the one I have now.
All right.
Thank you, my lord. I believe, my lord. Yes, my lord.
Okay. So actually,
my lord, that would be all for this witness.
Okay. And that is your case. Or do you have any other witness?
That's my case. No, my lord.
All right. Case for the second dependent. Okay. That means that's the end of this case. We are now looking at final written addresses.
Yes, my lord.
Yes, we are going to follow the method we use in getting the final written addresses. The defendant begins by writing up, filing, and serving the other counsel his final written address.
As a court, please.
I'm struggling to get.
Okay, to hear me. Okay. Why is this echoing? So, give me the other, mic. Okay. So, the defendant files and serves his final written address to the parties, and the second defendant also does the same. And upon receipt of the final written addresses of the defendants, the claimant's counsel also files and serves his own final written address. And each of the written addresses takes 21 days. So the first 21 days is for the 21 days.
My lord, before we adjourn, my lord, yes. I have an objection I want to make, my lord.
Okay.
My lord, I humbly want to apply for the CTC of the record because this matter has stayed long and I lost a principal. Most of the old records we have, my lord, due to relocation, because when we lost our principal, we changed office. So due to relocation, certain things were missing in some of our files. Some files were even completely missing. So I would require to get the CTC of the record of proceedings to assist me in preparing my address.
Okay, you mean the CTC of this matter since I came into
Yes,
it. I did not start it.
thank you, my lord. From the day you came into it, that is when we started leading evidence, de novo.
Okay.
Yes,
Well,
my lord,
you
because
do
that will determine my pace in submitting my own address, because I am to file first. I am the last to
Yes.
testify. I will file first, then the first defendant will file, then the plaintiff, then we have rights to replies.
Okay. Apart from demanding the record of the court, is there any other thing that I did not say here? The first defendant files and saves its final written address.
Yes.
Following which the second
defendant
defendant
file first.
Huh? The second defendant
filed first.
Files first, and
followed by first defendant, then plaintiff.
Upon receipt, the plaintiff, in fact, the first defendant also files and serves his own final written address. Then, upon receipt of this, the claimant's counsel files his own within 21 days. And when you get the claimant's final written address, you now have 7 extra days to write a reply on points of law. After that, the court starts thinking of judgment. So all these things take 49 days. Yes, 49 days. So this is a 2015 case. Give me a date.
So after the vacation.
Yes.
That is October.
Yes. We are going to take a date after vacation. So yes, to enable all these things to take place.
October 27th.
How do you stand on the 27th day of October?
October?
Yes.
My lord, we had a date already in October in this court. In the case of Andrew Kibet, I will be applying that we should take the same date, my lord, if that will be convenient to the court.
What dates are you talking about in October?
I think we took 22nd for judgment in Andrew Kibet.
Check it. Check our diary. 22nd. And for judgment of this one.
Yes, we took 22nd.
Is that okay? Yes, she confirms it.
22nd.
Okay. 22nd day of October. So this matter is now adjourned to the 22nd day of October 2026 for the adoption of the final written addresses of learned counsels to the parties.
As the court pleases, we are most grateful, my lord.
Very well.
Thank you, my lord. Have a
Yes,
nice day, my lord.
Mr. Hamzat, like I observed the other time,
My lord.
you look a little bit dull. For Mr. Hamza, you are looking dull.
Thank you, my lord. In the last proceeding of this,
Even now, the last proceeding you were yawning, and I told you you are tired. You must be tired.
Yes, my lord. Yes, my lord. In the last proceeding, what happened is that I traveled from Kaduna to Mina. I had a court session in the morning. So,
All right.
and I was having that tiredness in me. But today I'm not tired, my lord.
Okay, I see.
It's just
May
that
you
I'm
not be
fasting,
tired.
my lord.
Okay, very well. We'll see when we
Thank you,
see.
my lord.
All right.
Thank you, my lord.
Very well.
Thank you.
Please, can you speak up? Mary. So, Mrs. Ngozi, we are done. We are done for today. Thank you very much. You can log out.
I apologize for interrupting. I had mentioned earlier that I had a matter that will not be going on.
Okay.
It's the last matter on the list, number 14.
Okay. It's not. Okay.
There's a letter.
Okay.
Yes, number NNCS-LA, that 545 between Overland Highway and one, Okechukwu or government. Donor additional entity.
My lord, what is an absence, my lord?
Okay. Appearances, please.
May it please, my lord. My name is Adeleke Adekunle. For the claimant, my learned friend, Boti, our friend, is with me, sir. I'm most grateful.
Yes.
So there's definitely my record.
Yes.
Is there any okay way for the first declarant?
Yes.
This matter is supposed to be for continuation of trial.
I see. Yes. It's before the court. Okay. Mary. A date.
Same date, my lord, 22nd October.
Is the same date, all right? 22nd day of October.
I think it's better to think the same thing because Mr. Hamzat is supposed to be in the case as brothers. So that I won't take this.
22nd.
Yes, October.
So this matter is now adjourned to the 22nd day of October 2026 for continuation of hearing. Yes. So which one? Are we taking Felix Olakunle personally? And Nigeria Railway Corporation? Is there anybody who hasn't said his case? Okay. Number 5. What I mentioned.
Yes, my lord.
Case number NSN/LA 274 between Mr. Adela Adishino and MBA Microfinance Bank PLC. My lord, parties are absent, my lord.
Okay. Appearances. Yes. 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 Come again. No, your first name is Favor. Okay. Favor. Ineb. Dion. Spelled as pronounced. Okay. Yes. Okay. Who is there? Register. Date for hearing.
October.
October.
Yes, my lord.
October when?
27.
Eh?
27.
October 27th. How do you? Okay. Favor, how about you? So this matter is adjourned to the 27th day of October 2026 for hearing. That's commencement of hearing. Okay.
Case number NSN/LA 331/2024 between Early Machinery Dealership Limited and one Mr. Tony Yap, Matrix Global Trading and Shopping Limited. My lord, parties are absent, my lord.
Appearances, please. Yes. Yes. Okay. Is he coming anytime soon?
110.
Okay.
Okay. Before you.
All right. Okay.
It's not yet time. It's 1:30.
Okay.
And this.
But is there any other matter to be held?
Yes.
Which one?
We still have 54M 2023.
And
Number 12
We
is
see-
Oberland. It's the one we took virtually.
So they have different numbers. I'm giving you. Huh?
So you said yours is when? Who are the parties? Let's say.
But we still have another matter.
I think she's mentioning her matter.
Let's continue with the proceedings.
Okay.
Let's follow the serious.
This one is a heavy machinery.
Yes.
Okay, while you take it, while you find your case, let's.
Is it not
Chukwudego.
number 13?
Mm.
So we get there. We are not yet there. So we want to start this one down, my lord. This one is for fashion.
For fashion.
Yes, for you for 130.
Okay. So this matter is stood down for. It's stood down. Whenever he comes,
Yes.
This
is the next matter, my lord. Case number NFN/LA that contains 1326 between maximum chemical Uzmoko, okay, and one, 340, City Climate Leadership, RM, Russia Technology Policy. My lord is an access, my lord.
Appearances, please. Yes. I can spell Lugumba. Yes. As in who? See, I'm not hearing very well. What is really wrong? Come to the front and use the mic. Is there any minute?
We have an application. The motion is dated 2nd of March 2026.
2nd of March.
And subject to the providing comments of this honorable court, we are ready to note said application.
Okay. So, okay, this is a motion expert. Yes.
Our application is dated 25th of February 2026 and filed on the 2nd of March 2026. Lord, our application is brought pursuant to section 97 and 98 of the Sheriff and Process Act, Order 7 and 8 of the National Industrial Court Civil Procedure Rules 2017, Section 78 of the Companies and Allied Matters Act 2020, and under the inherent jurisdiction of this honorable court. Lord, the claimant applicant is praying for the following reliefs. Prayer 1, an order granting leave to the claimant applicant to issue a concurrent originating process in due suit for service on the first defendant, C40 City Climate Leadership Group Incorporated, a company incorporated under the laws of the United Kingdom, whose registered office and business address is situated outside the jurisdiction of this honorable court at 44 Featherstone Street, London, ECIY 8RN, United Kingdom, on Northwest entrance, City Gate House, 39 to 45 Finsbury Square, level 6 EC2A 1PX, United Kingdom, or through their officer's email address, mwat@c40.org and hchikoko@c40.org. Prayer 2, Lord. An order granting leave to the claimant applicant to serve the first defendant, C40 Cities Climate Leadership Group Incorporated, the originating processes in this suit, and all other subsequent processes ordered, hearing notices and correspondence by substituted means or alternative means, to read by electronic mail to through their officer's email address, mwat@c40.org and hchikoko@c40.org, or by any other means the honorable court may deem just, proper, and sufficient in circumstances. Prayer 3 and 4, such further or other orders as this honorable court may deem fit to make in the circumstances of this case. My Lord, the grounds upon which this application is brought upon. First, the first ground is the first defendant does not have an address within the jurisdiction of this honorable court. The second ground, the first defendant can be easily reached through their officer via email address. My Lord, in support of our application, we filed a 14-paragraph affidavit deposed by one Charles Olori, a litigation officer in the law firm of the counsel to the claimant applicant. And in support of the application, we have attached we have exhibits, Exhibit A and Exhibit B respectively. And we humbly urge this honorable court to grant all disposition contained herein the said affidavit. Also, below, in compliance with the honorable rules of this honorable court, we filed our written statement, our written address in support of the application, and adopt it as an oral argument and urge this honorable court to grant. Most obliged.
Okay. Council, this is ex parte. Nobody is challenging anything, but the court will not try the desk ruling now. because the reliefs that you seek, you know, they are quite lengthy, and they have all these names, figures, etc. on them, and the court needs to sit down and look at them. Yes, because there was the other one that was taken upstairs. That is why what they wanted the court to retract or to overrule. That was the first ruling we had this morning. So there's no point of my rushing a desk ruling and then find out that I should have done something else. I have to look at the addresses and the addresses and the areas contained in this. So maybe next week, okay, can you come back on Tuesday next week? That's what states.
That's Tuesday, no problem. I don't know about Wednesday.
Okay. Is that all?
Muslim, Wednesday.
Okay, Wednesday and Thursday.
Yes.
Well, that will be a salad day, public holiday. Of May. Okay.
Yes, ma'am.
Okay.
No problem.
Very well. So this matter is adjourned to the 26th day of May 2026 for ruling. Okay.
This number, NIS dash L is dash 4X. I think it's pushing as a and one word security image. My records are active.
Okay. Appearances. Appearances. Is that no representation? Parties absent. No representation. Is there any letter? Okay, give me a date for hearing of the applications of the interested party.
And I'll move to July 1st, ma'am.
July 1st.
Yes, ma'am.
So the matter is adjourned to the first day of July 2026 for hearing of the application of the interested party in this case. Yes.
Case number NNC/LA/44 2024 between Chukwudi Eze and TWGS Chukwudi Eze. TW. All right. Please, your name. Claimant is present, my lord.
Okay.
Defendants represented. Please, your name, ma'am. Miriam Dumoye. Miriam Dumoye.
Okay.
Your position, ma'am. Legal and compliance. Okay. Legal and compliance officer.
Okay. Appearances, please.
Okay.
Yes. For the claimant.
Yes.
Okay. Yes. I can spell a correct. Yes. For extension of time.
Based on that, if our witness gives us, we tend to respond to it. Other witness testimony. If our witness gives us, we still need to come back again.
Okay. Can you speak up because we have our family? Yes.
Don't worry, I have my voice. I can make it gone. Don't worry, my voice is louder than that.
I see.
I said the last
Are you sure? Yes.
the last part John said,
Mm-hmm.
the witness gave his evidence in chief. The defendant after that they still like start on the make for that day and taking of it. Start any motion to correct. My lord, if my lord will record, this matter was served on the 61. And that they just put in a statement of defense, nothing new, which compelled us to go on. And because from the assistant of this matter, they come in and they go back and back. Now this one is still well report. If they had served on this or prepared the area, we probably have even filed our return. They just sent me a motion on notice. That means they intend to regularize and process. And if our witness goes into witness box, because he has done the evidence, and today's matter is for cross-examination, he will still need to come back because we intend to respond to that statement of the person. They don't have a counter attached to it. So, my lord, in the light of this, my lord, we seek the guidance of the court because I may need to ask for cost because they had ample opportunity to have done this, which would have afforded us the opportunity to find our reply and defense to their counter affidavit. But they didn't do anything. The day before today, I'm just being served to show that yes, we are ready to defend this matter. And in the light of this, I think it should not be proper for a witness to go there and be cross-examined because that thing is still going to come back to for the further statements on both that we are referred to fund. And based on that, the defendant's action, this matter will not be going.
Okay.
And
Who is on the other side?
yeah, yeah.
Okay.
And of respectfully, I think demand can tell them one matter. The matter is that you want to ready. Let's not give us different from tell us how our kids. We're ready to control examination. I don't understand what you say. Because then you won't tell us we have the right.
I know that we'll get enough with that. I didn't even ask for, I've been asking for first. I know they can process, I mean, my people. They have a statement. The process is things have not been completed in this matter. Because they are still, when they enter trial, they are still bringing pleadings, stalling the proceedings of this matter. And this is a matter of 2021. And I cannot do a call. And on the last day, I'm not even sure they paid the complete report fee because what counsel I told the court was that the court ordered, because they made that last step and court ordered the file defense, which I tried to correct, mention that the court never did make such order. And they have ample opportunity. The last time this matter sat, the court delivered ruling in this matter, asking us, setting aside the earlier proceedings working July last year. And in March, a day before the matter came, they gave us a statement of defense, no motion to regularize, which is as good as it wasn't proper before the court.
Okay.
Based on that, as at then, the witness have to enter because there was no defense. Now they have come with the intention. I will find this motion of notice that we are ready to defend this matter. And he's telling me that I don't detect to him. But my Lord, from all indications, they are the ones dictating to the court the flow of proceedings in this matter. They are stalling the proceedings of the state. If they have filed these things earlier, and almost 1 year, this matter came up last July when the court set aside the earlier trial done in this matter. They never did anything until March, that the day before the matter came, and they just gave us statement of defense. Without even a motion to regularize. And another if I not do that, it's not of the matter. The defender has an habit of coming in and then they go back. So now they have come and we think they have shown seriousness. And I said, if it's cross-examined, you would be intent to respond. They have a counter. They have a counter. They intend to respond. It's to their counter and file a reply on their statement of defense. Then he's telling me that we are dictating to the court how the proceedings in this matter should be going. I'm asking for course because they have stored the proceedings of the case. I then filed this earlier. I won't be here as evidence is a court. There's nothing that prevents he came to be ready to be cross-examined. There's nothing that prevents him from being cross-examined. But the defendant, by reason of their attitude in this matter, have stored the matter to go. I know that we're asking for a cost of 200,000 naira.
Okay.
Yeah, I have not paid the cost that I think that's the greatest respect. Maybe he wants us to pay and I think that's the business of the day is cross examination. When you want to, I don't understand the.
So what is that process that you serve them?
We have found out what we serve them. Right? We have seen our defense, and at the proper date when our defense regularize our defense, if we want to.
But have you applied to regularize?
We have.
It's in the court file.
Yes.
When did you file it?
Well,
I was just today. While I was in court, they just said me that now. And they said they didn't ambush me. We have a right to defend and to reply to their defense. I also have a right to find a counter in this matter. Now that they said they are ready, my God, we have that right. They have stored this proceeding. You see the last adjourned date and today. If they have filed this thing on time, that they are ready for this, that they want their process to be proper before the court. In order not to waste the time of the court, we would have done it, but they waited for the day of our cross-examination, their cross-examination, to give me this, that we are ready to bring our processes proper before the court. As we talk, my lord, technically there's no process before the court. There's no process before the court. And once the process comes into the court properly, we
Actually, this thing was, has it been, is it before the court? Mary, is that document from the defendant? Is before the court?
No, my lord.
When did you file it?
I know what I found out defense in
the same motion.
found our
Yesterday, because I haven't seen it.
I know the point that matter I can't feel that there is nothing. See your matter. What is the point?
By the time they are making their asking for cost, we'll be recording our weakness. It should be on record. It should be on record. On the day they will use their motion to regularize, we're asking for cost because it will require our witness to be called back to the witness box to testify, to give his evidence in chief with respect to their counter and be cross-examined. My lord, if my lord can put us on record on that, I don't mind. But on the day they will regularize their process, I will be asking for cost. Put it in cost.
Okay. But confirm that they have paid the cost awarded against them.
Oh, my lord, they just went in court. But this is when they court. Something they get, my lord. My lord, in the same confirmation we're saying now. So I even have to check to know that they are paid. I was just checking before they permitted me. So somehow I got this was not the major thing, but my witness came to tell me.
But frankly, there's no need for this waste of time. Let's even assume that it don't happen. Set of things was examination, and we are not wasn't. Let us proceed with our witness, let's cross-examine the witness. We have the right to cross-examine.
I'm thinking of giving her the chance to. Of course.
Said that you want to find out certain things that may require that go home and continue and protect them. So what they say, the one that will tell
no, it's not time. Our witness will still have to adopt the witness statement from those. That's what it's saying now. In the midst of the court evaluation, in the midst of the court, our witness will still come back and adopt another witness statement for this court. This is evidence with respect to that witness statement of the court. How does it? If not, but it is time to avoid court. Not the law.
I will keep counsel to be
Okay. Thank you.
Case number NSN/MA/331/31 between Heavy Machinery Dealership Limited and one, Mr. Sonny Yaku, two, Market Global Trading and Consulting Limited. My lord,
Yes.
parties are absent.
Appearances.
My name is Samuel Ibrahim.
Yes.
My appearance is for the claimant applicant.
Yes. It's on the other side.
Is it not there?
Okay.
Has he
I'm
signed it?
just seeing somebody. This one. No, this is the council.
No, there's one that used to.
Who is on the other side?
Hello.
Yes. Okay. For the
For the defense of the Lord, I think I'll be led by my principal.
okay, you said so.
Oh,
But has he come here? You know, we just stood. So it remains stood down. Okay, is he joining virtually?
yes, yes.
Okay. Please just go and let him that
We are not seeing you. You're seeing everybody, but we can't see you, sir. We can't see you.
where is Shem?
Please tell them to log off. She's requesting to report.
Yes. Thank you for coming today. Eh? This is disappointing. I said this is doing something.
Okay. It's back. Because
Is it for Gabon? So somebody is muted.
okay, it's back.
Okay.
Good afternoon, my lord.
Good afternoon. I was
Yes,
checking
yes, sir.
appearances.
Yes, sir.
Yes,
Respectfully,
and
my
Mr.
lord.
Garba. Yes.
Respectfully, my lord. Ebuka Ekanyang for the defendants. And with me, sir, is Aloysius Paul Gapa. AP Gapa.
Yes. I've taken his appearance. He said, you are going to lead him. So
Very well, my
we'll be
lord.
waiting for you. Yes.
My apologies, sir. I joined early on time, but I don't know maybe the settings or something. Because I saw when you were taking appearances as well, my lord.
Okay. So now, the business of the court today is adoption of the final return addresses.
Yes, my lord, and we are ready to proceed.
Okay. You are for the defendant.
Yes, my lord.
Yes, so you come first.
My lord, they said they can't hear you.
Oh. Please open. It will start echoing.
Can you hear my lord very well?
Okay. Yes, so the defendant usually starts first to adopt the final written addresses. Can you hear me?
I can barely hear my lord. I don't know why it is. And they didn't share any codes, no, listen. Don't know how you have my mobile number, I have my address. Nothing was sent to me without party has. I don't have. This has always been the case.
So I can't give it because we are here. It's only the person I'm very virtual.
No problem. Let me hear it clearly. I can't hear anything.
Let me pass.
So I was saying, can you hear me now? I was saying that the business of the court today is adoption of the final written addresses
Yes, my
of
lord.
both learned counsel.
That's where I'm standing, my lord.
Yes.
Yes, my lord. So, my lord, the last agenda is I'm going to give reorder. The claimant should file its final written address and pay the default fees. We have raised an observation at the last agenda for the reason why we are unable to file our final written address because of the discrepancies we found from the type record, not the elections have it, the type records of the court. Be that as is known, we have complied with the elections order. Although we are unable to file before now, I'm sure by now they are almost done. I left them when we were paying for the default fees. So we have filed that written address as we spoke, but I'm sure it is not before my lord.
No.
With application for regularization.
Okay.
But before that, my lord, we have filed an application, sir, seeking to reopen the claimant's case and call additional witness.
We've not been served with any
application.
of those
Yes,
of that
we
application
have
as
not,
well.
sir. We have not, sir. There are issues with payments, and I'm sure they are still having that payment. The platform was not coming up, so we were unable to file it. I have been out of town taking everything. I just came back this morning for this case to discover that it was only the application I filed. The other one is being filed. I saw it. I was there at the register there. They are filing the register address now. So at any rate, even without those issues, we will be ready to go as it is.
You'll be able to
rely on the final address. But the client himself insisted that we should file this application. So I want one way or the other, the election should give an order, a ruling on it. Whether it's an order, it's not an order, it's too early, it's too late. So that my own records will clear that yes, I comply with the client's order. But then I have to comply with the election order by filing the final address.
you filed, but it has not been served. Announced. Mr. Ekanya, have you received anything?
I'm quite confused. I don't know this. I'm not sure I understand the logic behind council submissions. He's saying a lot of things at the same time. He said he wants to file an application to reopen the case. We have not been served with that application. That application is not before the court. He said he has filed his final written address. That application is also not before the court. There is no scintilla of evidence that application is currently being filed before the court, and we have not been served with that application. My lord, as earlier submitted, we are ready to proceed. There's been a lot of back and forth. My lord is quite aware of the history of this case. And I don't know if we will continue to go on like this. I don't know, my lord. But I will leave it to the court's discretion. My lord, may I also want to add that there is a Supreme Court authority which I would like to refer my lordship to. This is not the time for submissions. This is not the time for any sort of bravado. But I just want to refer my lord to this particular authority. It is a Supreme Court authority decided in 2022. It's Gidia and others versus Sanusi and others. And I would like to quote the citations. Law Pavilion Electronic Law Report -58932. Supreme Court. The particular area of concern is at pages 10, paragraph D to E. And I would just like to refer the court to, your lordship's learned senior brother, Abba Aji, GSC. He says, where one party fails to file his written address, it is not a bar to the other not to file. Besides, by Order 36, Rule 17, 18, and 20 of the High Court of Niger State, the option is on the party to file written address or not. My lord, the NIC rules have similar provisions as well. That where one party files a written address, the other parties are at liberty to file or not to file. Either way, it behoves on that party to do the needful. And if he fails to do the needful, the court is obligated to proceed, with hearing the submissions of counsel who has filed that final written address. My lord, that is what this authority is saying. Like I said, my lord, the court is a very fair and justiciable court. The court always insists on hearing the other side before making a determination on an issue, and yes, which I am quite happy about, because justice, is not a one-way street, but it's both ways. My lord, however, this is the fourth adjournment, my lord, and we are still hearing stories that it is before the court, it's at the registry, they're having issues with payment. My lord, a counsel who is diligent in the prosecution of his case, my lord, this is the claimant's case. A counsel who is diligent in his prosecution of case will not wait till the day of hearing to be filing his final written address. My lord, this is unacceptable. And this is a total disrespect of this honorable court. My lord, law school students are even here. And it will be sad for them to be witnessing this kind of practice. This is not the practice that should be encouraged. Whatever the case, I'll leave this decision to the court's discretion. I do not know what the counsel is submitting. I do not understand the logic behind it. He's dribbling me. He's probably dribbling the court. I do not know, my lord. But what I do know is that we want to finish this case because they brought us here. And we are tired. My client now is beginning to think that I'm deliberately delaying the case for no just cause. I don't even know how to explain to the client. My lord, that's all I will submit, my lord.
Okay. You heard him.
Complaining here about the complaining. If they are giving me this quote, you have been better for it, but they don't want to give me the quote. I don't know why. This is the first time they refuse to share this quote.
To share what?
She was saying that because I'm not virtually, she cannot share with me. It's strange. Since this case started, this is the first time she's refusing to share that with me. And I'm becoming very suspicious. I must say this now. They have to better.
So please, mind what you're saying, please. What you're saying is today is slated, the matter is slated for adoption of final written addresses. Can't you see that it looks odd that it's only today? It's today that your final written address is being.
I really apologize for that, my lord. That's
but it's affecting the court. Yes, it's affecting the court. And to keep on adjourning this case is also not good for the courts nor for the litigants.
So let's say we have to file a reply. If not, we are ready to adopt it.
A reply to what?
The final address now.
Have you served them with yours? Leaving your own final written address and filing their own reply on points of law.
That's what I'm saying. That unless you want to file a reply report which they are entitled to, if not, we are ready to close this case today.
Reply on point of law. We are not with any. We have not been served with any process. There's nothing before the court to respond to. There's nothing before me to respond to, my lord. My lord, sir.
You are telling us that you will rely on their own final written address.
No, I didn't say that. We have filed a final written address, my lord.
You have. They have filed.
We have filed, yes, my lord.
Where is it?
I don't know if your lordship's copy is before my lord, but if my lord can just give me just 5 minutes to just go to the police place and fetch it. Just 5 minutes.
This the court has given this case a lot of time. So 5 minutes will be too much to grant.
2 minutes. It's the police office just by here. Just close by here.
Are you appearing alone? Why can't somebody just go in and look at what you want to go out to see? Are you appearing alone, sir? Are you appearing alone?
I'm appearing alone, my lord. Where is me? I'm not alone. Where is me?
God is with everybody. Well, I don't think the court will wait until we find out all these things. I guess we have to leave it to another day and maybe part the other side at the back.
Alert.
Yes, because the business of the court today has been scuttled. The courts personally even have an issue, an appointment somewhere. So, having waited till now, we can't wait any further. Maybe we just do.
The man is even confused. Running up and down. You are not here.
Is that your client?
Yes, my lord. Not my client is one of my staff in the office.
Okay. So they have finally filed it.
Yes, my lord, but they want us to serve their office. We will do that.
No, I didn't say you should serve that. He can serve me in court. My lord, you didn't say we want. I didn't say he wants. Let him serve me in court. I'm ready to accept it.
I'm serving here and he refused to collect it.
He said he's ready to collect it in the open court.
Mr. Paul, please take it. There's no harm in collecting process. It's a process now.
And then what do you think will happen to the courts?
Well, I leave that to discussion report, my lord. If they want to
be asking for cost, my lord. I'm happy he has finally filed. My lord, I'm gladdened. There's so much joy in my heart. I'm happy. Whether he's filing today, whether he files in the future, at least he has finally filed. We give thanks to God Almighty. My Lord, now, because he has scuffled the proceedings of today and several other days as well, my Lord, I'll be asking for cost of 500,000 naira. My Lord, this practice should not be encouraged. My Lord, this is the 4th time that he is doing it before your Lordship, and my Lordship will bear witness. The court's record will bear witness. I'm not just asking for this court because I just want to ask for it, but this is a punitive measure to ensure that such practice is not adopted before before other courts and even before your Lordship's court in the future. My Lord, this is a deterrent measure, and there is a rationale for this cost request. My Lord, that is what I'll be asking for. Who will respond?
We are not talking at the same time. I understand you. You cannot be talking. My lord, I don't know the kind of practice we are seeing here. Sit down, we're talking, my friend.
There's no final.
What did you say, though?
Time within the money, and then another application for additional witness. Then a copy of final. This process
No, this is what I'm saying. No, this is what I'm saying. Wasting your precious time, wasting our precious time, wasting precious judicious time, taxpayers' resources and funds. My Lord, this is what I'm saying.
Okay, he has handed you the correct. Okay. I will have to look at the other side too. If it has just been served on him now, he has the right to read what has been served on him.
Yes, my Lord, we'll be happy to respond. Yes.
Yes, and to do his reply on points of law and all that. So, give me a date.
Is it date for adoption or just for?
Oh, it's for adoption. Yes. Council, at least you agree with me that they have the right to read what you give them now. I said they have the right to read that document you just said on them now, which means that we will take another date anyway. Give me a date, please.
Any Wednesday or Friday is convenient for me. Any Wednesday or Friday, my lord.
Any Wednesday or Friday. This 20, July. That's all right.
My lord, July is convenient.
Okay. Let's check a date.
Well, we also have a natural right to respond.
Of course.
Yes, my lord.
I don't have any date in July. I prefer June.
No, we don't have any.
June
is not coming.
I'll be traveling in July. Unless it is
first week. June is convenient, my lord, for me.
Okay. He said June is convenient for him. Mr. Aikano.
There's no date in June, man.
When the court is closed, and June.
My lord, if you can just squeeze us, my lord. If you can, it's just for adoption.
Just find any day for adoption.
I'm grateful, sir.
Okay.
She said Wednesday. What? Wednesday and he said any Wednesday and Friday. But we don't. Friday is not good for us.
June 17th.
June 17th.
17 is convenient.
Okay. Is that all right for you?
No, my lord.
June 17th is not all right for you? It's 15, what days of the week? Second of July, how about it?
And on 2nd of July is a Thursday. If my lord can, 2nd of July at 2 p.m. is convenient, my lord.
Okay.
2nd July is convenient.
At 2 p.m.
July.
Not 2 p.m. My lord.
Yes.
Let's stick to our usual 1 p.m. time.
No, my lord, 1 p.m. will not be convenient, my lord, sir, because I will have to drop my son in school between 1 and 1:30.
The indulgence is becoming too much. It's becoming abusive.
I don't understand.
I don't understand, my lord.
He is there.
The indulgence. Who is indulging who?
But because I consider to him his written address virtually. If I cross it, it will go. I consider, but it cannot be crossing his own time.
My lord, sir, I don't understand the language of counsel.
Let's stick to 1 p.m. I have my reasons.
Come to think of it, the time for virtual hearing in this court is usually from 12. It was only in the last case that they said 1 because
12
of the
convenient, yes. Anything 12:1 is okay for me. Morning to 12:1 is okay.
Would that be all right for you?
My lord, sir, just a moment. Let me check.
There should be.
My lord, 12 p.m. will not be convenient for me, sir. That is 7 a.m. my time, which I would have to use to drop my son in school. My lord, I'm humbly requesting my lord, sir, to please, my lord, we have indulged counsel on the other side on so many occasions. And his filing of final written address is even evidence of that fact, my lord. My lord, I'm asking for 2 p.m. or any Wednesday date, my lord.
This second day of July, what day of the week is it?
The Thursday, my lord.
The Thursday, my lord.
Mm.
No, we're guided by the rules of this protocol. Even if parties fail to come, the lordship can
Yes, if
adjust as adopted. So it's not.
if anybody doesn't come to adopt his final written address, the court will assume that you have adopted.
To personally adopt my written address, my lord. My lord,
Yes.
which is why I'm asking. My lord, I have a right to seek the court's audience, respectfully, for a convenient time, just like the way counsel on the other side. We can both agree on the time that both works for us. I have mentioned 2 dates that he has disallowed. So why is it that I'm mentioning my own time and he's saying no, it must be his own time? Why? Despite
No,
all the
I don't think
your
he's talking
lordship has
about time.
granted him.
The court wants us to adjourn it to 2 p.m. at least. 1:30 to 2 p.m. How does it affect
Second, my
you?
lord.
Second day of July 2026, between 1:30 to 2 p.m. What is wrong with the timing?
My lord, I will see how, if I can make it, maybe somebody to come. But that 1 p.m. will have been ideal for me. Anything to, I'm supposed to be somewhere.
Training for
I'm a
1:30
very
since, my lord. We have never had this virtual proceedings at 1 p.m. My lord, I'm even asking for 2 p.m., not even 1:30. That's what I'm asking for, my lord, so that I can have the opportunity to do the needful, domestically.
Okay. Would that be all?
Yes, sir.
You're not asking for anything? You're not asking for anything?
For cost, my lord.
I'm not asking for, I'm not getting you, my lord.
Okay, I said, is this all you want to, you have agreed to the 2nd July 2026 by 2 p.m. You say you can send somebody to come and get it.
I thought my lord said 1:30 p.m.
Then I said 2. Let's make it 2. Or 1. 1 or 2.
My lord, 1
2
p.m.
p.m. is good. My lord, my lord, sir, I can't make 1 p.m., sir. Please, my lord,
Listen,
sir.
where are you?
I'm in Ontario. We are 5 hours behind. 1 p.m. is 7 a.m. my time. That is the time I have to drop my child in school.
Any day this week, any day that's convenient this week, I'm ready.
I can't believe that the taking of a date has cost us this time.
Or move to maybe second week of July, if there's a convenient date, fine.
Second week of July. Please, you have a diary there.
Second week of July.
8 to 9.
8 to 9.
8 July or 9 July.
Please check.
If it's convenient, my lord.
Which one of them?
8th, my lord.
Okay.
8th July at 1:30 is fine. 1:30 is fine. 8th July at 1:30 is fine. 1:30 or 2 p.m. 8th July.
So, at long last, this matter is now adjourned to the 8th day of July 2026, 2 p.m. for adoption of the final written addresses of both learned counsel to the parties.
As the court pleases.
As God pleases.
Okay. He was talking of cost.
Yes, my
What
lord.
do
I
you
made a
have in
request
mind?
for cost. I made a
For
request
what?
of cost of 500,000 naira, my lord, for stifling to these proceedings and stifling other proceedings prior to now, my lord. My lord, till today we have still not proceeded with adoption.
He is saying that he's asking for a cost of 200,000 naira, 500,000 naira, as the cost for scuffling the court's proceedings and other ones, according to him.
My lord, we've paid cost of 200,000. My lord, we've paid cost today again. My lord should make it cost in cost. So that this matter can. We have decided to allow for God the issue of those documents that can concentrate on what we want.
When last did you pay any cost? 100,000.
That was 3 proceedings ago. Three proceedings ago. My lord ordered.
That was in March.
Yes, 3 proceedings ago.
Okay, I was on 26 March. The court awarded a cost of 100,000 naira.
Yes, my lord. 3 proceedings ago. My lord, this is the 3rd proceedings after that adjournment of the 26th of March.
We are not going to award the cost cumulatively. For what happened today, and for the fact that the court is still in court till now, when I'm supposed to be somewhere else, I will award this cost for today. So the claimant is awarded a cost of 200,000 naira only.
As the court pleases.
My lord, it is not our wish for this matter not to go on. It's like I raised some issues that even the court's registry, the platform for payment,
I agree with you. I agree with you.
It's too much for the claimant.
My lord, grateful, my lord. Most grateful, sir.
The court is not supposed to be here now. But since I'm here, because this is my work and I cannot abandon it to go look after myself. So this cost is just for today. It's just for today. I didn't award for the other days.
As the court pleases.
So that is it. 8th day of July, by 2 p.m.
Thank you, my lord.
Thank you.
My lord, may I seek your permission to log out of these proceedings?
Just hold on a little bit in case.
As the court pleases. Yes. As the court pleases.
Is there any other one? So I think we are done. The case is over. So I guess we can log out.
As the court pleases. Most grateful, sir.
Very well. Okay. Is there any other? No, my lord. Is this the end of the case? Where is my officer? No, 1 second.
put that this one inside the phone. No,
You want what?
please. No, let me put it inside that brown envelope. That my man made envelope. Abi.
You just throw the water.
Okay, just put it inside it. No, put it inside the envelope. I'll carry it straight. Carry it straight. Just put it inside this. I'll carry it. Tired.
You know, sleep. But let's sleep. What do you want? Give it. Change it now. Yes, what I